CR1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in BSI Holdings, LLC versus the Arizona Department of Transportation. Counsel, we have read your briefs. We've conferenced this case this morning. I would alert you that we are recording these proceedings, but I do need you to stay at your table and speak into the microphone so that we can all hear you. Appellant's counsel, if you wish to retain any time for rebuttal argument, it's up to you to make sure that happens. Please state your name before you begin and identify the party to whom you represent. With that, we'll hear from the appellant. You can remain seated. It probably picks up in the microphone better.
May it please the court, my name is Ben Updike for the Arizona Department of Transportation. In this case, the Supreme Court remanded the case to tax court with instructions to determine the meaning of based in this state from the statute ARS 28836, and then, after doing that, to determine the number of days the aircraft had been based in Arizona during the relevant periods. The tax court failed to comply with this mandate and instead erred by finding it ambiguous or nebulous and ruling in the taxpayer's favor. Here, we should comply with that mandate and adopt a domiciliary analysis of based in this state for a certain number of days, and then an examination of the evidence in the record shows that this aircraft was based in Arizona at all relevant times.
Counsel, I do have just some really basic questions for you. First of all, you recognize that for the purposes of this statute, that an aircraft can be based in multiple locations throughout the course of a year?
It can be. It could change its base during the year. For example, when ownership changes and the aircraft is transferred to another state.
I'm just one owner. They can have multiple bases.
That is also true. It is possible for one owner to have multiple bases, although under a domiciliary understanding, you can't have multiple bases at the same time. You have a base, which is your primary place of headquarters or where you return to, and then if there's the evidence to support it and that base is abandoned, perhaps temporarily, and there's another base established somewhere else, then yes.
If we were to adopt that, I mean, we would be writing into the statute something that isn't there that says temporary or permanent. I mean, it just says number of days based in Arizona. Why shouldn't we just look at based as in how long the plane has actually been here?
Well, the Supreme Court rejected the understanding of just looking at the number of days, the presence test. That was the argument that went up to the Supreme Court. Instead, it said, we want to interpret based in this state and then for a certain number of days. And in doing that, if you look at the statutory context, the definition suggested by the Supreme Court that based suggests a primary place, a headquarters, or
But if you take that approach, couldn't theoretically you be based in a number of states more than 365 days of the year?
You mean?
Well, if I have in this case, if he had a base in Minnesota and a base in Arizona, and everybody was taxing that person not based on the number of days, but just looking, couldn't theoretically they be based more than 365 days? Both jurisdictions would say, yeah, you were here long enough, or we're going to make that accommodation.
Well, there are generally in taxes principles that both jurisdictions, two different states, would not tax the aircraft at the full rate if it's split between them. That's some interstate tax things based on federal law, but it is possible that one state could have a slightly different understanding of based, and so it might have a count of 100 days, whereas Arizona might have a count of 270. That could add up to more than 260, I guess, theoretically. But we're not talking about theory here. We're talking about this aircraft has not argued or shown that it was based anywhere in this entire period, except for some admitted short amounts of time it admitted it was based in Arizona if it was here for 24-hour periods, or it also admitted that by registration that it was based here at least 90 days in the year. So in this case, we don't have that theoretical potential number of days more than 400, 365. We have.
Well, hold on, because you're saying we don't have that here. But we're not just asked to address this case. We're asked to interpret what based in Arizona means. And I'm saying if we're trying to figure out what that means, theory does come into play. We wouldn't interpret this statute to mean that you could have something based in Arizona when somebody else could tax it. So aren't we limited that there's going to be a set number of days, a universe of days, 365. Some of those days are going to be in Arizona, some of those days are going to be somewhere else. But it can't add up to more than 365.
Again, under Arizona's understanding of the statute, it shouldn't add up to more than 365, because under the domiciliary analysis, you would have a base which you would establish through totality of circumstances, and then you would find when the base started, and that base would continue on a domiciliary analysis until it was shown to be abandoned. And then when there's evidence to show that there's been it's been a change, that it's been abandoned because a new base has been established, then you would not add up to more than 365, because it would start when you show the base beginning in Arizona, end when you show that it ends in Arizona or is established somewhere else, and then it would start again when the base came back to Arizona. So under that theory, under the domiciliary analysis, you have one home, one main headquarters, one base, and then it continues until it's changed. So under the Arizona understanding, consistency would add up to 365 days. Your question of whether or not another jurisdiction may tax it differently, I don't know all of the jurisdictions. They may have a different definition, and so there may be some conflict there. But under Arizona's understanding, if we adopt the domiciliary understanding, then no, there would only be one base at a time. It would be changed if it went to somewhere else, if you could show that it was abandoned, and then it would start up in that place, and then when that was abandoned, it would come back, and they showed it comes back here, then it would start here again.
Mr. Updike, I have to confess, I've got some concerns here, because this discussion is rather academic, but I think my concern is there's this concept and these factors is nowhere to be found in the statute. There is nothing, as far as I can tell, that was ever put forth by the department in terms of a rule, a regulation, a published policy to taxpayers that outlines any of this, including the various factors that your auditor laid out in his affidavit. So where's the guidance? Where's the notice and guidance to the taxpayer as to these factors and this standard that you suggest? And I'm not criticizing the department for not anticipating the Supreme Court's parsing, if we'll call it that. But I am troubled by the lack of meaningful notice to not just this taxpayer, but other taxpayers in a similar situation, so they can understand what's expected of them and comply with the law.
I hear what you're saying, and as far as I know, there was no rule promulgated or definitions and something put out by the department, but
and I'm sorry to interrupt, but I'll just get this off my chest. So, I mean, this issue's been pending with this particular taxpayer for quite a while. The issue about the interpretation and application of the statute's been pending at least since the completion of the audit and the issue of the assessment. But from that point forward, even though this has been battled, there's been nothing by the department, as far as I can tell, to try and clarify the application of this statute.
Well, I hear what you're saying, but I don't think that the department should promulgate a rule based on presence, which the Supreme Court then rejects, and when it's being litigated, then promulgate one based and then have it be rejected by this court. I think that would provide more confusion.
See, I don't read the Supreme Court's opinion that way. What I read their opinion to say was, in the absence of clarifying legislation or written direction by the department as to how it intends to apply the statute, then we're going to speculate about what maybe you should do in this case, based upon facts that aren't yet in the record. That's personally the way I interpret it.
Well, I understand it slightly different. I understand that they said there isn't something here in the statute that defines how to interpret based in the state for a certain number of days or the other statutes that are operative here. And so we can look to the principles of statutory construction to understand what it is. And they suggested that, but then they said, we're sending it back to the lower tax court to implement those statutory construction principles and then find a meaning of based in the state, which at the tax court level, the department provided an interpretation. The tax court refused to adopt any understanding of the statute and said it's nebulous, we're just going to say there's no meaning. But the department has been pushing an understanding since the Supreme Court mandated it that it does make sense to do a domiciliary analysis, especially when you look at other parts of the statute that are related to this tax scheme. For example, the residency statute, which cites to 210 or 7 months, and other things do suggest the domiciliary understanding. So it's not an analysis the department has created out of nothing. It's something that is also present in the statutes, which taxpayers are assumed to be aware of. And when you look at all of the statutes and put them together, this is the analysis that comes up. There's no other currently suggested understanding of what the statutes mean. So leaving it without meaning would violate the principles of the duty of the court to give meaning to the statute if possible and not leave it void or negated.
Hasn't, I mean, is there an argument that the taxpayer has conceded it is based here? And we don't, I mean, I can't really disagree with the Supreme Court. That their opinion is what it is, but I'm not sure I understand what the controversy about whether this plane is based here or not, because the taxpayer, I think, has conceded it is based here.
Well, the taxpayer has conceded it is based here for some amount of time, but denies that it's here for sufficient amount of time to hit the 210-day. And without...
And we know from the Supreme Court that it's not just mere presence.
That is correct.
Our court, an original decision, said any time you're here, it would count, and the Supreme Court rejected it. So we're still down to basic, to where we were in the beginning, is what does days based in Arizona mean?
And that is correct. It said, look at the entire phrase and interpret the whole thing together. The aircraft based in this state for a certain number of days. In order to do that, you have to look at some kind of record, some kind of evidence. We've always suggested that the flight records matter, and because it's not just presence, other things matter as well. The ultimate person who directs the aircraft, showing its intent and use of the aircraft, the person who supplied capital to purchase it, the people who use it and what they use it for. In this case, all of those things are tied to Arizona. The aircraft has contracts with hangars in Arizona. The aircraft is used to travel from here to various places around the state and then returns here. All of that shows that including the flights from Arizona and back being so sufficient that it's most here compared to all other places in the country.
Do you think that creates a presumption that shifts the burden of proof to the taxpayer?
Well, I think that the evidence we have in this case is sufficient to not only create a presumption, but also to have no ability to be rebutted, since there is no evidence in this case to suggest that the base has been anywhere but Arizona for more than 156 days, or 365 minus 210, and then has to be greater. So there is the taxpayer has not argued it's based anywhere else specifically, only that it loses its base in Arizona when it leaves, it disappears, and then the remaining time in Arizona is not higher than 210, which again would be a nightmare to administer.
I don't understand that, because you can look at the flight logs and know that Winner wasn't in Arizona.
I understand what you're saying, but going back to your original understanding, does that mean it abandons a base when it leaves Arizona and creates it somewhere else and it has 47?
You start off by telling me you could have multiple bases, so yeah, it does.
By mere presence?
Yeah. If it's not here, how can you say it was here for a number of days based in Arizona?
The same way I can say I'm a resident of Arizona if I'm vacationing in Colorado. I can still be a resident of Arizona just because I left Arizona, even for a month or two, to go do something in Colorado. It doesn't mean I lose my residency. And in the same way, you don't lose a base merely by leaving it, as the Supreme Court said, that it is not a mere presence, and they suggested that you can have a base.
Mr. Updike, you admitted that this statute is ambiguous. And you admitted that we needed to do some statutory interpretation. And the Supreme Court has said if we can't find it clear from the language, we're supposed to interpret it in favor of the taxpayer. So all of your argument goes the opposite, that we should interpret this broadly against the taxpayer. And yet you just admitted to Judge Winthrop that there's nothing in the regulations, there's nothing that would give notice to the taxpayer about this.
Again, when a statute is ambiguous, it means it is subject to two different understandings, one proposed by ADOT and perhaps another proposed by the taxpayer. The taxpayer has failed to create that ambiguity by proposing its own different understanding of what the statute means. It has only said it's unclear, and therefore, it has not presented an alternative argument, an alternative understanding. It is possible for the court to reject our understanding of what the statute means and propose a separate one, and therefore find what it means, but rejecting the department's interpretation without proposing an interpretation, which is what the tax court did, is not finding the statute ambiguous. It is refusing to construe it at all. And without any construction, how can you adopt the construction more favorable to the taxpayer if there is no construction at all and no meaning? So I understand what you're saying, that it might be, that it could be ambiguous because we've been arguing over what it means, but they have not proposed an alternative meaning for how to determine where an aircraft is based and then how to count the days after you determine that.
Haven't they, maybe I misread this, but hasn't the taxpayer suggested that based in Arizona requires some sort of intent to remain? And I'm not saying I understand what that means, but do you have any understanding about that?
So the taxpayer actually in their brief said there can't be an intent to remain because aircrafts are inanimate objects. But then earlier at the tax court they'd said, well, the aircraft, it doesn't intend to stay in Arizona. So they've mixed that up. Under the department's understanding, the aircraft is inanimate. It technically can't intend or will anything, but the users, the owner, the person who directs it, can have an intent for the aircraft, which is why, again, you should look at the owner, the people who fly on it, that sort of thing, to find out what the intent is for the use of the aircraft, whether it's commercial for a different kind of aircraft or here it's personal. So it does have an intent, and that intent is to be based in Arizona. This, under the definition of base being the place where its primarily headquarters is or use or where it intends to remain, that is Arizona. It has come back to Arizona every year. It does fly away sometimes for the summer, but again, the taxpayer has not proposed any number of days where it is based in any other location except for at the very beginning when it registered in Arizona and said, well, actually, technically we're based in Oregon, even though never once in the entire period has it gone to Oregon. That is the only place that it is actually identified as being based. Otherwise, it says, yes, we admit we're based in Arizona, but we lose that base and we're not based anywhere else, which is not an interpretation that's able to be applied. So there has to be something that can look at this aircraft and
Well,
be able.
hold on. You say they haven't given you something, but I'm reading their complaint, and yes, they did. They said that it reflects a legislative intent to define day by its plain and common meaning, a durational period of 24 hours beginning at midnight and ending the next immediate following midnight. That's right out of their complaint.
That's the definition of day, not based in the state.
But they've conceded that they were based, and they're using that definition to determine the base count for the days to fit under the statute.
I understand that they're using a period for determining a day, but they have not proposed what it means to be based. How do you know when you lose your base? How do you know when you gain your base? When does it start? When does it end? They haven't proposed any of those understandings. They've just talked about day, and the court said we need to go back and look not just at day, but at based. So they have proposed a definition of day, but they have not proposed a definition of when to determine how you're based there or not during any given day. So the department has proposed a way to find out whether you're based here or not in any given day. using the domiciliary analysis, defining when it starts, finding when you've abandoned it, assigning your domicile, and then saying you have the burden of proof to show that you lose your domicile based on some certain evidence. For example, you've gone away and established a base somewhere else that proves you've lost this. And again, all of that is in the statute based on, if you look at the residency definition, where they say, for a vehicle resident, determine whether or not you're a resident. For a vehicle, you can look at these 7 things. You can look at whether you have a home here, which is similar to having a hangar here for the aircraft, whether you have a business here and you're doing some sort of commercial work, which is also available for the aircraft, that if you do have interstate commercial activity, then you're also considered based here. There's those sort of things. And if we adopt the others and into the statute for base, then it does provide an understanding of a domiciliary understanding. And then we can go from there and adopt the other domiciliary principles from other tax types and then say, yes, we can use these principles to clarify what it means. I have 30 seconds left. I would like to reserve time unless you have more questions.
Thank you, Mr. Updike. Counsel?
Good morning, Your Honor. On behalf of myself, Christopher Rapp, and Leslie Sorensen, my partner, we represent BSI Holdings. It's an Oregon LLC. It's the client in this case. I'm going to start off. I'm surrounded by tax brilliance. I am not a tax lawyer, but I'm going to start off with a quote from Yogi Berra, which will show my age. This is deja vu all over again. We are here back in court arguing a very similar argument that has been made before. But I also want to point out that as I've listened to the argument, the court has talked about several things, but Justice Bullock made a very clear ruling. And the law of the case now is that the Supreme Court has issued is at the end of the day, do we have the tools and send it back to Judge Whitten, the tax court, to determine if the tools of statutory construction could define based within the state, could define this legislative addition to a referendum that was voted by the public in 1964, where the change of the statute at the time was instead of the 0 to 90 days operating in Arizona, it was based within the state, and then they added another 120 days where they gave a tax break. The problem is the legislature doesn't have any record as to how to look or what its intent was to create an additional level of tax benefit to a non-resident aircraft that is based within the state. So what the things I take from the Supreme Court was they have a sentence right at the end where they say that the taxpayer has to have a clear notice of its obligation. And that's confounded me throughout this case, which I have been involved in since 2013, is the lack of any direction from the department. Where the department came forward, we slugged it out for 5 years over the term days, Mr. Updike and myself. But they never could say is, did you ever send out an email, put a pamphlet, promulgate a rule, go back to the legislature for clarification as to days or based within the state? There's a lot made, I think, of admitting. Go ahead, Judge.
Look, you've conceded by all of your submissions that you are based in Arizona. You can't, you're judicially stopped from saying you have not been based in Arizona because you've submitted to the department that you are based in Arizona and your complaint says you are based in Arizona. So we now have to determine how we factor your concession that you are based in Arizona with the number of days you are based in Arizona.
Correct, Judge.
And I just heard the department say that you can have multiple bases. So with that in mind, are you not based in Arizona every time you leave Arizona?
I think we are not present in Arizona. We have we have conceded based in Arizona, Judge, clearly, because the statute requires us to get the tax benefit to be based within the state. That's the direct language of 8336. It says based within the state. So to get the tax, so for 2004 to 2012, during the audit period, we were based in Arizona for between 90 and 210 days and filed an affidavit to that effect and paid the tax.
So, Mr. Rapp, sorry to interrupt, but what I'd like to understand, because I couldn't figure it out from the record, how did your client calculate the number of days it was present in Arizona, based in Arizona, between 90 and 209? How did it do that?
Well, Judge, when he was no longer in the state, no longer present within the state, he went to Minnesota in the summers, Texas for a number of trips, Las Vegas. Those times he was not here the number of days. So when he calculated, it was based on flight logs, or you've seen the reference to FlightWise, which we didn't use. We used flight logs. And may I interject just one quick? Go ahead, Judge. I'm sorry.
Well, it's just trying to follow up. And so is there in the record, on a year-by-year basis, the number of days that the taxpayer believes it was based in Arizona?
So, Judge, we submitted.
I've seen the department's calculation,
Right.
and I'm suspecting yours is different.
So, Judge, I don't know if we're supposed to talk about the first go-round up to the Court of Appeals.
It's all part of the record.
Yes, Judge. So we submitted our days based on two different factors. We submitted to Judge Whitten, and actually in the EHO hearing, but to Judge Whitten, the first motions for summary judgment, the number of days, calculating days based on 24 hours using flight logs.
What I read in the complaint. That was your position.
That was our position. Then, Judge, we submitted a secondary, because of the case law, for a 12-hour analysis. Because, as Judge McMurdy just said, what if you are based and you fly to Las Vegas? That's, 45 minutes, right? So you're there 12 hours, you're there 11 hours and 15 minutes. What day? How do you calculate a day based on that? So we went through another analysis with a 12 hours. So that was submitted. Judge Whitten in the first summary judgments, accepted the 24-hour rule, which now the Supreme Court has not wholeheartedly accepted, but he said that it's the 24 hours, therefore he accepted those days in that ruling.
So going back to the 12-hour, your position, correct me if I'm wrong, but your position is, if you were in the state of Arizona, if the plane, not you, if your client's plane was in the state of Arizona for 12 hours, that would count as a day. You would accept that.
I would have to accept that,
Well, you
Judge.
didn't, but you wouldn't have accepted it because in 2009, you tell us that you had 223 days with 12 hours or more, but I assume that in 2009, you did not declare that you were over 210 days.
No, we did not, Judge, because we used the 24-hour analysis. And that was after we went through the case, went through the EHO, and in summary judgment, we looked at the case law in regarding tax and saw some issues in regard to, even though the department has its own definition of midnight to midnight, 24 hours, which they've never used in one of their regulations, we decided to say, well, if there is an issue, there's some case law that talks about a day being over 12 hours. So we used both analysis. Judge Whitten accepted the 24-hour. You're right, Judge. We would have conceded at this point in 2009 the 223 days based on a 12-hour analysis. However, Judge, with the ambiguity in the statute, that it is ambiguous, the interpretation by the taxpayer is 24 hours. It is what a day was. The Supreme Court has said, if by the tools of statutory construction, you have to go in favor of the taxpayer. Now, the analysis of days is, I think still is a little bit murky to me anyways, but I think the question is we used 24 hours and that was the interpretation by the taxpayer.
Well, but your concession to what Judge Bailey just asked was, you've conceded that 12 could be an appropriate interpretation, but it would require a remand for you, for that one tax year, which you dispute.
Well, Judge, I think Judge Bailey's decision, Judge Bailey's statement was, didn't you not concede that in 2009, with the audit period being through 2012? Our interpretation throughout was the 24 hours. So, no, we were under 210 days in that year, Judge Bailey, but in going back through those and submitting alternatives to the court on the definition of day, we did go back and configure from the flight logs the number of days we were out of state at that time in front of Judge Whitten. The first time, not the second time. So Judge Whitten ruled, well, I'm using the 24 hours because that was the interpretation by the taxpayer.
So, and I just want to be clear in my mind. So if we said presence in Arizona for 12 hours would constitute based in Arizona for this statute, would you agree with that?
If the Court of Appeals rules, do I disagree?
Yeah, you do it in a petition for review. What do you think?
I would be very, yes, we would absolutely pay the tax. Judge, it's based on the value of the aircraft at that year and all that. So
I'm not talking about an aircraft that just lands here for 12 hours and then takes off. That's not what I'm talking about. I'm talking about if you conceded you were based here, so.
I did.
And now you say, okay, every 12-hour period, 12 hours and 1 minute,
right.
that we've conceded that is a day in Arizona.
We were absolutely willing to do that at the first go-round in regard to the battle of days and the the department's claim that a momentary drop on the ground. We didn't, Judge, and not to go into too many weeds, but the whole issue of, well, you wait 23 hours and 50 minutes and then you take off and claim you weren't here a day. I find that to be offensive as you land here, you go get a Coke and then you take off again, that's a day. So we tried to give a number of alternatives to Judge Whitten in this case because the taxpayer and looking at the tax law. But during the audit period, when my client signed an affidavit that said, I'm here between 90 and 210 days, that is what he calculated. That is what BSI, the entity, calculated as the number of days for purposes of the tax, barring what we found in 2009. And I thank you, Judge Bailey. I'd forgotten all about that.
So, Mr. Rapp, your client's use of the plane, its location, and its travel in and out of the state, has that pretty much been the same since the plane was acquired?
It was, Judge. My client used it for the entity that owned the aircraft used it for trips outside of the state, outside of the country, and that was, Judge, just on a side issue, the flight-wise, we never used that because you lost the aircraft outside of the country, and so you all of a sudden just showed up somewhere, so we weren't able to calculate. The flight logs are much, much more accurate. But
so my question really goes to, there was a closing agreement reached with the department in 2003?
Yes, Judge, right after acquisition of the aircraft.
And based on the department's understanding, or the taxpayers providing information and an agreement as to how the plane was used and where it was located and how it came in and out of the state, there was an agreement reached as to the tax treatment of that, right?
There was, Judge, and that was drafted by the department. It was.
Have you ever claimed that the department is stopped from changing that interpretation in a retroactive fashion?
One of my partners now is watching this jumping up and down because estoppel.
Well,
Yes, Judge,
estoppel is a very difficult principle to.
Against the government.
To proceed on, at least against the Department of Revenue.
No offense to the Department of Revenue.
But I haven't seen that argument raised in your briefs or.
Well, Judge,
hearings
it
below.
was, that was one of our primary arguments below the first time. But estoppel was never, the 2003 closing agreement, we actually moved a judge for the years 2003, 4, and 5 for partial summary judgment initially based on the closing agreement, based on estoppel, because of they filled in you're using it for this, you're not using it for interstate commerce and all the other things. And then they never defined days in that, which was one of our points all through. But yes, estoppel has been an argument that we have made. It became abandoned with Judge Witten's rulings on both occasions, the Court of Appeals, Supreme Court. So then we got into the issue of based within and days. But estoppel, as of the closing agreement, has been a primary part of our complaint. And I don't know if it's in the complaint you're reading, Judge, but it was fairly prominent in some of our motions. And we still have that available to us, I believe. Kind of lost the thread on it, where it went after the Supreme Court, but so.
No, you've got 4.5 minutes left.
Okay, so a lot of the arguments that my very learned colleague makes about domiciliary and the tax structure of aviation and those analysis are not within the actual words of the statute. They don't exist. And to try to have the taxpayer have to do some guessing game makes no sense. But what the Supreme Court was very clear on is the requirement that there be a clear notice of the obligation to the taxpayer. And that's all the taxpayer in this case wanted, was what do I do? If you told me how to calculate days or based within at some point between 2003 and 2012, there would have been some ability to get our affairs in order as the Supreme Court. And not to attack the department, as Judge Winthrop pointed out, there's no one that can say with this statute how the permutation went with the Supreme Court. But their inconsistency, and Judge Witten alluded to the inconsistency of the department in the way that it handled this, in the way that it wanted the payment. And in essence, to this court, what the department wants is to have a definition that completely obliterates the statute and the plausible legislative intent to give a non-resident aircraft some kind of a tax break, and have it so that there's no way to comply with that by the definition of days or the definition of based within. But the interpretation by my client was that they flew it over 90 days, they flew it under 210 days using 24 hours as a day, and it was based within the state of Arizona during that time. And so at that, as the court alluded to, when there's ambiguities in a tax statute, this court should rule that Judge Witten's decision is affirmed.
Can I ask one additional question that just popped into my head? With respect to the fees that your client pays for services at Arizona airports, the tie-down fees, hangar expenses, those are paid on an annual basis, whether the plane is here or not?
I think there's a argument that the tie-down would be a lease provision, Judge, for a longer period of time. However, other services like fuel and repair and those types of things would be on a ad hoc basis, because as they've alluded, he spent many months in Minnesota and had the same configuration there to have fuel, repairs, pilot services, and
there's-
tie down.
But there are certain fixed costs associated with being based in Arizona.
Absolutely,
The
Judge.
tie-down fees, hangar rental, right?
If they had a hangar, yes, Judge, yes. So, a judge I know called me and said, "Don't talk too long." So, first, thank you for hearing this case, and as usual, after this incredible year, I hope that your families and you have stayed safe and healthy. Thank you.
All right, thank you, Mr. Rapp. Mr. Updike?
I've got a couple of things to say about why the 12-hour rule is absolutely unadministratable. Because if it's, as they say, 12 hours, they technically mean 12 hours on the ground in Arizona and not present in Arizona, because there's flights where you're still in Arizona, but you haven't crossed the border. You can't determine if you crossed the border. Also, if you were to look at it, for example, if you stay in Arizona for 11 hours, fly to Nevada that day, stay there for an hour, fly back there, or 11 hours, fly back to Arizona, stay here for 11 hours, and the flight is an hour. If you do that every single day, 365 days, and that's all you do, you don't meet the 12-hour test, because you're only present here for 11 hours, and so you're not based anywhere during the entire year. You're not based in Nevada, you're not based in Arizona. That sort of analysis does not work. Only something that provides an answer in all the circumstances, like a domiciliary analysis, is administratable.
All right. Anything?
Nope, I'm good.
No, thank you.
All right, the matter is deemed submitted. Thank you very much for your arguments here today. We'll issue a decision in due course.